Happy meteorological winter.
Yeah.
Everybody. Okay, so we do have a quorum present today. We have Chair Brewer and Supervisor Seep joining us online. And then Supervisor Cosgrove is out sick today, so he won't be joining us. And Supervisor Rudersdorf is not here, but everyone else who's on the committee is in the room today. So we have a quorum. Agenda item number 2, proof of notification. The agenda was posted online. There's someone who's a very fast runner at about 9:58 every day right before this meeting, and her name is Ms. Dahl, and she goes down those stairs and gets my agenda that I send out 5 minutes before the deadline. So thank you for doing that, Ms. Dahl. Agenda item number 3, agenda approval. We've got a 10-point agenda, so I'm looking for a motion to approve. Motion by Frank, second by Fleming. All those in favor of the agenda, please say aye.
Aye.
Opposed, say no. Okay, that motion carries. Agenda item number 4, public comments. Is there anyone from the public who wishes to comment to the committee? Okay, hearing no one, we'll move to agenda item number 5, approval of minutes. So I'm looking for a motion to approve the minutes of the November meeting of this committee. Motion by Glassburner,
I'll second it.
second by Gentis. Any discussion on those minutes? Okay, all those in favor, please say aye.
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 Opposed,
Aye.
say no. Opposed, say no. Okay, we have approved minutes. Agenda item number 6, ethics review. So in the latest segment of our epic efforts on ethics review,
Oh, yeah. Here we are.
just to remind folks what we did at the last meeting in November is we made recommendations on the nepotism policy. We made recommendations for the privileged information policy and definition. And we referred an example public property policy or use of public property policy to the standing committees for their feedback. I know the Public Works Committee, they discussed it at their November meeting. I listened to that conversation. The other committees have not discussed it. And just yesterday, I sent out requests to those other committees. So Supervisor Glassbrenner got it for HHS and veterans, and I sent it to the other ones as well. So I think we could probably wait till January to discuss any feedback we get on that. So today I put a couple of new attachments in made them available for the committee. One is on a social media policy, and the other is on a computer use policy, which would cover email. So we've skipped over those sections in the previous discussion. So I thought maybe we could circle back and just grab those in order. So the email policy, it's at the bottom of page 3 and it's just left blank. The other counties, so we don't have anything on our ethics ordinance about email. The other counties don't have anything in there about email. But we do have a very large section of the our existing computer policy, which was proposed by MIS and adopted by the Finance and Personnel Committee, I think 6 or 8 years ago. So there's a very large section on email in that computer use.
It's just on page 3?
So on the cover sheet on page 3 at the very bottom, there's just a little box and it says email. It's just a placeholder.
Oh, okay.
For us to insert anything there if we want to. But I see that Mr. Langrecht's pulling up the computer policy. It's a 10-page policy, and the section on email starts on page 5 of 10, and then it goes on for
right. I read.
3 pages because it also kind of bleeds into open records. So I just wanted to show that to folks and see. Supervisor Gentis, I think you brought email up, so I just wanted to give you the space to make sure your ethics concerns are being addressed here.
Well, I looked at it. I guess what I was concerned about was that I find it hard sometimes to write a long email on my iPad, so I use my home computer And sometimes I mail from there, but usually if it's important, I send it to my iPad and mail it from there. And I didn't know if there was anything unethical about that. And I couldn't find anything on here about that.
When
Linda,
you're- hold on,
if
just
I,
hold on just a second. I just want to ask a question here first. So Supervisor Gentis, are you using your county email when you are on your personal computer, or are you using your personal email when you're on your personal computer?
I'm using my personal. I don't have my county on my computer, so I'd have to get somebody to help me put it on my computer.
Okay, so
I don't know how to do that.
Ms. Scott helped me get my county email added to my personal computer because I have the same issue. So I sometimes will.
Oh, that's a good idea. That would help me a lot.
Okay.
Okay.
Ms. Scott, were you going to add something? I just wanted to clarify that first before we got into this. Okay, I'm not hearing her say anything here. So I don't see it addressed in here either. I read through this, but I think that's a way you can make sure you keep county business on county email, just in case there's ever an open records request and you don't want to have to expose all your personal email.
Oh, I do so many personal things.
Open records request.
You're right. Yeah, yeah. No, I think that's good. Okay. Does anybody else have that problem? Well, I find when I have to write a long email, it's hard for me to do it on the iPad. So I do it on my home computer. And when I know, I send it then to my county email and then I forward it, but then you have to, erase a bunch of stuff and it doesn't look as professional. But I just have a hard, this isn't that bad to type, but when you really, yeah. So I didn't know if anybody else had that problem. Because with HHS, you must have a lot of emails.
Mr. Chairman,
Hold on. Let's let Supervisor Glassbrenner answer, and then Mr. Seat. Can you just speak into the mic and then just share maybe how you're dealing with that? Are you using a personal computer or using the iPad to type out all your emails?
Using the personal computer. If I have to do a long email, I have logged into my email, my county email on my personal computer where it's easier to.
So you have your county email on your personal computer. Okay.
Okay, Mr. Seat.
I'm thinking of the Hillary Clinton example.
Wait, what?
If we use our personal account on our own personal computer for the discussion of county business, that makes that computer subject to, whether it's a computer or a cell phone with a text, subject to public records. Is that correct? Public records law.
I don't know if there's a clear answer, but I think to be safe, we should probably do our county business on county email.
Yeah.
I think
And that's not what I was saying, just to clarify. I'm using county email.
On your home computer.
Yes, correct.
Oh, I'm sorry, Ingrid. I wasn't referring to your comment.
That's fine. I just wanted to clarify that point in case anyone was wondering.
So that any topic that we discuss with another county board member or employee should be discussed only on any topic of county business. Be discussed only on our county account, correct?
Well, I think that's the general custom we're saying we should have. We don't have it written down anywhere. And if we want to, we could either put it in the ethics policy or we could just say, maybe we just recommend that the computer policy be amended. We could do it either way. But do we need to handle it here? I don't know. I'm just only bringing it up because Supervisor Gentis wanted to. And so we could just say for the email, we could have something in our ethics ordinance that says refer to the county's computer policy. And then we could take it there and then handle it later there, but we could just have an unwritten custom that we just use our county emails for county business and not our personal emails. I'm
Now,
open to however you all want to do it.
if I may follow up just with some clarification questions.
Sure.
We may get, for example, hypothetically, we may get an email from a citizen inquiring about a county issue, and it may come to us on our personal account, on our personal email account. But the inquiry is about county business. That then, we know that any letter to a county supervisor or a county employee regarding county business is subject to public records law. So therefore, if we receive an email regarding county business on our personal account, that makes our personal account, in that case, subject to public records, yes or no?
This is Administrator Langrick. I'm not your corporation counsel and offering you what the legal answer is on it. I'm just offering you my novice interpretation of what the open records law is. So yeah, it really comes down to the record. If you have a discourse back and forth with the citizen regarding a county topic that you're addressing in capacity of your position, then I would consider that a public record. If it's on your email, then it would be subject to release. It really comes down to a recommendation of practice. If that does happen, you might be best served by forwarding that email chain to your county email, because how we would typically entertain a public records request of that nature is it would go through MIS and through
Yes.
John and the help desk, and they would be doing an inquiry into our exchange, our email exchange for those types of records. So if they're in there and accessible through that exchange, it might help mitigate the need then to go into your personal Google account or whatever types of a thing if you can produce that record.
Or one could also forward it to the county clerk with a request to file for public record. Right?
If you didn't have it forwarded to your existing email and there was a request,
Yes.
Yes, you could forward it to us and it would arrive at the on the
I
server.
wonder,
exchange.
Mr. Langrick, if it might be helpful to get on that specific question, to get a letter of advisement or opinion from our corporation counsel on record.
I can ask him that, but I think you would agree that the best and safest practice is to use your county email for county business.
Yes, I understand that, but I think it's good to have it in writing.
Mr. Chair, can I ask what we're discussing here in regards to this?
Yeah.
Yeah, I
'cause we
feel like
don't
I'm getting lost in the
So
weeds.
we
What are,
might get a little too far afield here. I think the issue is that Supervisor Gentis just wanted to make sure that she was doing what's ethical with email. And I think we've got a solution for her now, which is to get MIS to help her put her county email on her personal
Mhm.
laptop. And I think that kind of addresses the concern. And so, yeah, and that's what I've done. And I don't know if everyone's done it, but you can, they'll help you have it put on your personal laptop, and it does make life easier. It gives you different options. So maybe we can just move on from that one. I'm not hearing
Okay.
anyone.
Oh, I'm fine with that, but I think all those advisements should be in writing as a matter of policy.
And we do have the computer policy, and I think that computer policy can be amended to include this the next time that comes through. And I know Ms. Scott's on the line, and I don't know that I feel like it's super urgent, but I think next time it comes through, I think the computer policy is mainly directed at employees, and it might just need to be widened a little bit to include officials.
And I'll be honest, we've just finished a rewrite of the computer policy that Clinton hasn't seen yet. So I'm not ready to move it forward, but it is broader to encompass board members. Because when that was written, we really weren't utilizing it as heavily as we do now.
Great. Well, that's perfect timing. So and that'll go to finance and personnel or to public works. How will that work?
The way I have been handling it is I send it to Public Works to forward to Finance and Personnel, but of course Clinton could just send it to Finance and Personnel if that was what he deemed was appropriate.
Okay, so stay tuned for more discussion on that and pay attention to the computer use policy if you care about that one. And I'm sure we can always go look at the the Wisconsin Attorney General's advice on this. I know there's a packet on that. Yep. Mr. Frank?
Mr. Chairman, why would it go to Public Works?
Because MIS reports to Public Works, but it sounds like it's going to go to Finance and Personnel. But that hasn't been decided yet. The issue is that the computer policy was approved by Finance and Personnel back when MIS reported to Finance and Personnel, and now they report to Public Works.
I see.
Mr. Frank?
Thank you. So Wisconsin does have a open records training that is available. State employees, and with some of the projects I do, I'm required to do it every 3 years. It's online, it's free, you can just search for it. It's a really good document. And under that training, one of the comments is the location of the record does not matter. Emails, text messages, or files about government business on your personal device are public records. You must keep them and turn them over upon request, is their statement from the state of Wisconsin.
That answers
So it
that.
includes text messages. That's kind of what I
That's
was
just
wondering.
fine with me.
So it sounds like you can kind of do what you want, Supervisor
Yeah, but make it
Gentis, but
Be clear if I got it on here.
The legalities come down to producing them when requested. So it's, if you have text messages again, or emails, then maybe in your best interest to forward those to your county email to have them saved and available for request.
Absolutely.
okay, thanks Supervisor Frank. That helped to have that read out to us. So let's move on to the social media policy. So I'm hearing no action on that one. And I'm just scrolling down to see where that's at. I believe that was next in line. Yes, it's right after the public property policy. So it's on the bottom of page 8. So again, this is not in our ethics ordinance, but we do have a policy on social media. It was adopted in 2014. And just to regard that note at the top of page 9 about what attachment it is, you don't have to go to September to look for it. You can look for it in your folder for December, and that's 06D social media policy. And again, this is approved. I think the last one was approved by the Finance Committee. I know this one was because it says it at the top, the social media policy. So I know there was widespread agreement amongst this committee 3 or 4 months ago that we should address social media in the ethics ordinance. So I dug this out of the employee portal because this is in a list of policies that all employees can see at the county. So it's a 6-page policy. Do we want to do what we did for the, let's see, there was another topic that oh yeah, nepotism. We took action to include in the ethics ordinance on the topic of nepotism. We would say refer to the employee handbook. And so on this one, do we just want to say refer to the social media policy? Is that okay?
It's very complete here, I thought. Unless there's more.
I just wanted to note that this policy was developed in 2014,
Yeah,
and it only talks about county employees, does not talk about elected officials as well, just like we were talking about the email.
Yeah, so Ms. Scott, I don't know if that's in your idea hopper eventually too, but it just sounds like, and I'm sure you would already do that.
Yep,
It
and
just-
we'll just broaden it like we did the other one.
Excellent. Okay, thank you. So let's just get a motion to say on this one, we'll get some language in the ordinance that says refer to social media policy. So someone want to make that motion? Okay, motion by Glassbrenner,
I'll second it.
second by Fleming. Any discussion on that? Okay, all those in favor, please say aye.
aye.
Opposed, say no. Okay, that motion carries. So we'll get that added to our chart here. Okay, so we pretty much handled all the topics now. except for the public property one that we'll come back to later when we get input from others. So now it's the process. So the process of handling complaints. There's a few different topics, so maybe I'll just run through the topics first under process. So one part of the process is advisory opinions, like how those are issued, who issues them, all that sort of stuff. The next topic, this is at the bottom of page 9, is the complaint procedure. So how do we handle complaints? What form are they expected to come in? What information do they have to have? And then after the complaint's received, what's the investigation procedure? And then finally, what does the enforcement look like? So sometimes I think when we were talking about public property at the last meeting, I started thinking, we're not going to go around and investigate these. We're not actively looking for these cases. What we're doing is we're just creating a framework for when someone complains. This is how we view it. So this kind of helped me to remind me of what's the process here of what we're doing. So let's just go ahead and jump into advisory opinions. And if you want to do this a different way, of course, just jump in and let me know. So our current ordinance says, I'm just going to read these out because I did not read these ahead of time, so it'll help me and hopefully it helps you. And if someone else wants to read, jump in. So our current ordinance says that the ethics board shall issue advisory opinions with the assistance of the corporation counsel. The identity of the requester for an advisory opinion shall not be made public without the consent of the requester, nor shall an advisory opinion be made public without the consent of the requester. However, a summary of an advisory opinion which does not disclose the identity of the individuals involved in the opinion may be made public. So I think if, someone wants to come and say, well, I would like to put a bid in on a county request for, I'd like to sell a piece of equipment to the county because I own a business in Richland Center and we sell equipment that the highway department wants. They could come to the ethics board and they could say, I'd like an advisory opinion on if I should submit a bid or if I can even do this or not. And then that's an example of what an advisory opinion would look like.
Mr. Chair?
Yeah.
Is that this advisory, the option here that you're talking about, is that only for property that you're talking about, or is that any ethics violation? So example, it could be for the email one that we talked about, or any of the other ethics. Is that only for the property?
No, I just use that as
Okay,
an example. But it could be for any ethics issue.
In the ethics policy?
Yeah.
Okay.
Exactly. So do you all want, I'll just read the Crawford-Sauk County example so we can compare what we have today to theirs, and let's see if we want to make changes to ours. So in Crawford and Sauk counties, they say any person covered by this code of ethics may apply in writing to the county corporation counsel for an advisory opinion and shall be guided by any opinion rendered. The applicant shall present his or her interpretation of the facts at issue and the applicability of provisions of this code before the advisory opinion is rendered. All requests for opinion and opinions rendered shall be in writing. Records of the corporation counsel's opinions, opinion requests, and investigations of violations shall be closed to public inspection as required by Chapter 19 of Wisconsin statutes. However, such records may be made public with the consent of the applicant. So any opinions about whether you like ours or theirs?
I guess I'm seeing ours is has a lot of similarities. I don't see that there's a problem with ours at this point.
I don't know. I mean, it's kind of nice that the Crawford County example references the statute as to why it's closed to public inspection. I didn't really, when I'm reading through that, it's like, okay, when we just read ours, it's like, why is this not allowed to be made public? And so that, I guess, clarifies it. I don't think we have to have that in there, but
It's a good reference, I like that.
Yeah.
Well, and also they said that our corporate counsel is all private, right?
Say that again?
Doesn't it say that the corporate counsel's opinions are private and not open?
See, it does say that in
In the Crawford,
it does say that in the Crawford.
yeah,
Sauk
I mean,
County
that
example.
spells that out.
Ours says, ours says something similar though.
Oh, I must have missed it.
It says, nor shall an advisory opinion be made public without the consent of the requester.
Mr. Chair.
But-
Yep. Supervisor
there's-
Fleming and then Glassbrenner.
The Crawford Sauk County example, what Linda is referring to, also states not only that their opinions are closed, but also their the court requests are closed, but also their opinions and their investigation.
Yeah,
They're listing all of it. And then I like the fact too that it states the statutes.
yeah.
Now, we will have an investigation procedure section. So you're right, it does say that investigations will be closed, but maybe that'll be handled in a couple topics. But okay, so there are three things here. There's requests, and then there's the opinion. And it lists both of those out in Crawford and Sauk County. Do we list out requests and opinions in ours? Do we say that the request should remain?
No, and I was actually also going to say the last sentence and the half of the sentence before that are a little confusing. It says, nor shall an advisory opinion be made public without the consent of the requester. However, a summary of an advisory opinion may be made public. I'm a little confused by that. What is the difference? How would you summarize an advisory opinion that's not an advisory opinion?
I'm thinking of it was a particular situation to use as an example of Gary Mannon and his business, and would it be ethical for him to put a bid in on a type of a project? And we didn't want to release that out specific to Gary, but if it was then put out in a generalized summary of supervisors that are engaging in this type of activity, it's not advised that they do this. It'd be more summarized to generalizations versus the specific supervisor is how I would
Okay.
see how that might apply.
So then I guess I would want to see the reference that they make to the Wisconsin statutes. I'm assuming then that kind of thing is okay, because they make it like nothing is going to be released. We're saying we can generalize, which I would assume would be okay, but it's just interesting that they differentiate, I guess.
And visualize it in context of just like state statute, then you'd have a reference to almost like a case law or an attorney general opinion within our own ordinance that you could possibly reference that summarized opinion asterisks underneath your ordinance if it got to that level with a code ordinance.
Okay.
Chapter 19 is general duties of public officials. Were you looking that up? Supervisor Frank, did you find anything?
I did not find anything specific. Chapter 19 covers a lot of territory. So them just putting chapter 19 is nice as a reference, but it'd be really nice to have the sub to know what they're talking about, whether it's, it covers everything from ballots to votes to open records to, so if we're going to put the statute, I think we need more clear to identify what that is. Closed sessions is 19.851. Closed sessions by ethics or election. That's elections though again.
19.59, that's codes of ethics for local government officials, employees and candidates. So I think
There you go.
that's maybe the section, but how do they actually address it in 19.59? I don't know without taking some time to read that. I'm almost kind of hearing that folks are liking the Crawford Sauk County example. I see another difference though, that we currently say that the ethics board will issue advisory opinions with the assistance of Corp Counsel, whereas in Crawford and Sauk counties are saying the Corp Counsel will issue the advisory opinions.
Mhm.
So that's another difference. Do we want the ethics board to be involved in that in partnership, or do we want Corp Counsel to take the lead on that?
Mr. Chairman,
Yep, Mr. C.
the advisory opinion would come to the ethics committee or board, and it seems to me that based upon his advice, they would make a decision and issue an opinion or a decision based upon his advice. Since the corporation counsel is not a member of the county board and not a voting member of the board, and therefore is not responsible for action by vote, it seems to me that the proper procedure would be for the committee or board to solicit the advice of the corporation counsel and follow that such advice as it and apply that advice to its decision or opinion, perhaps making reference to it or not. That's only the way I see it, and maybe there's a broader view of this than what I'm expressing.
Well, I personally, myself, I agree with that. I think we could just, in the Crawford Sauk County example, just strike where it says Corporation Counsel and replace it with Ethics Board in all those locations. And we'd, of course, be working with the Corporation Counsel to get their assistance. I don't know that we need to spell that out in the ethics ordinance.
I think if I might just follow up a bit, it seems to me like when we're dealing with questions of ethics here, it seems to me that almost always we would be seeking out the advice and counsel of our corporation counsel.
Okay, well, I'm going to make an attempt here. I'll make a motion that we adopt the Crawford Sauk County example with the exception of replacing Corporation Counsel with Ethics Board wherever it appears in theirs.
Because the ethics board is a decision-making body.
Are you going to include, like, with the assistance of corporation counsel, are you going to add that in there, or is that just assumed? It's probably, I would
What do
assume.
you think we should do?
I don't know. I guess I don't know. Is it in our purpose that we solicit the opinion?
We haven't done the purpose yet. That'll be later.
I think, Mr. Chairman, I think there's a good question there. Is that Supervisor Glassbrenner that raised that question?
Yes, Mr. Steve, I apologize.
Yes, I think that's a very significant point. Is we perhaps would need the assistance of the Corporation Counsel in guiding our communication of the decision, because we could communicate it improperly, even though the advice was good advice. We might without his assistance, we might make a mistake in communicating our reasoning in the decision. So I think the assistance of the Corporation Counsel would be helpful.
Okay, how about in the second to last sentence, it starts, and this is in the Crawford Sauk County example, it says records of the Corporation Counsel's opinions. So instead of it saying that, it could say records of the Ethics Board's opinions made with the assistance of the Corporation Counsel shall be closed to the public inspection, blah, blah, blah. Just include it right in that sentence, maybe. So how about I'll make a motion to do all of that, just replace Corp Counsel with the Ethics Board, but make sure that the assistance of the Corp Counsel is still mentioned in it. So that's the nature of my motion. Let's just copy it just like Crawford and Sauk County with those exceptions.
Mr. Chair?
Yeah.
It also states at the beginning that you're applying in writing to the Corporation Counsel.
So
So it would be implying a writing to the Ethics
Ethics
Board.
Board.
And so is this made public so people would know who is the Ethic Board, how to, where to send the written request? And then also, I mean, is the is the whole ethics ordinance online, so people know when or if there would be an ethics violation.
Okay, so your first question first. So we'll handle that when we get to the introduction about what the governing body is. We're
Okay.
assuming it's the ethics board, but we haven't talked about that yet. And how they would, they would apply, they would submit it to the ethics board. So then all our contact information is listed online for whoever the ethics board is. So I think it would be clear, I think, but then we need, as far as the ordinance, I don't believe the ordinance is currently online. And I think what we could do is we can post online once we adopt a new one. I don't think our ordinance today is it's not real comprehensive. So I don't know if it's worth going through that time. Anyone can request it. It's on our committee's website, buried in the materials right now. But it should be online, and Mr. Langer has been doing a great job of getting policies that we pass online on his website.
And you do have, Clerk Kalish is working with Muni Code, I believe, that we have monies aside to try to get our code of ordinances codified and put online. So it's a project that has begun.
Chair, so,
Mr. Frank?
so looking at the Richland version, it says, shall issue advisory opinions with the assistance of the Corporation Council. Isn't that what you're saying you want to add into the Crawford Sauk County?
Yeah, it is. You're just saying, just add that sentence.
Well, I'm just going back to the one that Richland already has.
Mhm.
There's a lot of good stuff in there. Kind of sounds what you're trying to say is kind of what they're already saying.
Mr. Chairman,
Ms. Glassbrenner and then Mr. Seat. Oh, Mr. Seat, go ahead.
yes, I'm thinking of an actual example in past history where we have had an ethics inquiry, and we, in that case, hired an outside investigator to report to us, and then the findings of the ethics committee or board, which were assembled as a result of the investigative report, were forwarded for action, for recommended action to the personnel committee as the action body. And that would apply in most cases, except where if it were an employee, except where the employee's status had tenure under Chapter 17. So I don't think that the disciplinary action would be vested in by that example, would be vested in the ethics board or committee, that they would merely report their findings with a recommendation to an action body, which in that case in the past was with the personnel and finance committee. Just whether that sheds any light on this discussion or not.
What if we just took the first sentence from ours and we added it to the front of the Crawford Sauk County example, and then we replaced the rest of the Crawford Sauk County example where it says Corporation Council with Ethics Board? Would that suffice? Supervisor Frank, I'm thinking that some people liked how they made it more clear that the request for opinions and the opinions rendered shall be in writing, and records of those shall be closed to the public, and all of that. So what if we just kind of married the two different ones together in that way? Okay, I'll make the motion. Will you second that?
Yes.
Okay, Supervisor Glassbrenner will second it. Would anyone like me to read that? Or
Yes, please.
I'm a little lost in the woods.
okay, so I'll read the motion basically. And the motion is to have it read like this. Shall issue advisory opinions with the assistance of the Corporation Council. Any person governed by this code of ethics may apply in writing to the ethics board for an advisory opinion and shall be guided by any opinion rendered. The applicant shall present his or her interpretation of the facts at issue and of the applicability of provisions of this code before the advisory opinion is rendered. All requests for opinion and opinions rendered shall be in writing. Records of the Ethics Board's opinions, opinion requests, and investigations of violations shall be closed to the public inspection as required by Chapter 19 Wisconsin statutes. However, such records may be made public with the consent of the applicant.
I got it.
Mhm.
Live with it, Bob, okay? It's a little wordy, but the thing I'm thinking about Chapter 19 too, now that you said that there was a closed session section or the open records, or there's other pieces of that, it might be best to keep it open-ended because there might be different components of Chapter 19 that apply to.
Which is
this.
probably why they left it like that.
Could be.
Okay, so I made the motion, Glassbrenner made the second, so all those in favor of that motion, please say aye.
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 Opposed, say no. Okay, that motion carries. So we've got an advisory opinion process established. Complaint procedure. So we have in our current ethics ordinance, we go to 8A through F. And this is an attachment A. And this would be attachment 06A ethics ordinance. Sections number 8, A through F. Oh gosh, A through G. I hope I don't have to read all this. Maybe I'll just try to give a high level view. So 8A, all complaints of the ethics violation must be in writing and must contain the following information: name, date, nature of offense, supporting facts, date, which it occurred. B, while persons filing complaints of ethics violations are encouraged to identify themselves in the complaint, anonymous complaints will be accepted. That got changed. So our current ethics ordinance, you can't do anonymous. There was an amendment to this ordinance. And that's later on in the document, but just know that that's changed. You can't do it anonymously under our current ordinance. Letter C, complaint shall be filed or mailed to the county clerk. D, the county clerk shall make copies of the complaint form available to all department heads and distribute a copy of the form. It should be in the handbook of personnel policies. Letter E, the ethics complaint form is only suggested, but any form of a complaint shall still be considered by the ethics board. Letter F, after the complaint's received, the board shall hold its first meeting on the complaint within 30 days in closed session. If the board decides to investigate it further, it shall hear from the violator. And then if after having investigated it, they decide this ordinance has been violated, they shall apply an appropriate penalty. And then the last letter, nothing in these procedures shall prevent the ethics board from investigating a possible violation of this ordinance by a motion made by a member of the board. I don't quite know what that means, but so that's our current.
I think that just means we as a board can say we think there's an ethics concern with A, B, or C, and then if we adopt it as a board, we can investigate it.
Oh, something else?
That's my understanding of it. Like we could say we have a concern, like I could come to our board because I'm on the board and say I have a concern about this matter. I think we should investigate, and if we adopt that as a board, we can investigate it.
Oh, I see. Okay. Thank you. I'm not quite, yeah, my head's not quite in it. Oh, but yeah, you must be right because Supervisor Frank's agreeing. So, okay. Okay. So that's our current process. And again, going back to, we're looking at the complaint procedure here. So in Crawford and Sauk counties, let me just read these two examples because theirs are more brief. Maybe see if we want to go for something more brief. The Corporation Council shall accept from any person a verified written complaint which states the name of the officer or employee alleged to have committed a violation of this code and sets forth the material facts involved in the allegation. The Corporation Council shall forward a copy of the complaint to the accused officer or employee and the Ethics Board within 10 days. If no action on the verified complaint is taken by the Ethics Board within 30 days, the complaint shall be dismissed. A different take on it. And
Wait. Oh, go ahead.
and one more example, Iowa County is even shorter. All complaints regarding violations of this ordinance shall be made in writing and submitted to the county clerk, who shall deliver them to the chairperson of the Ethics Board.
So can I ask a question? So the ethics boards will decide if it's a valid complaint? Is that what I mean, that's sort of confusing of that one that if it's nothing's done in 30 days. So if you're the complainer, what do you have? I don't quite know how you.
Yeah, they just, in those kinds of, it's almost like they just stay silent. They just let it drop.
Yeah.
They never issue an opinion or a response or.
Yeah.
Well, I mean, I like brief, but I think Iowa County is too brief. There's really nothing laid out there whatsoever. And I would agree with you. I think it's only fair to have some sort of parameters on how we respond to a complaint. If we're soliciting them, we should then also be accountable to issue some sort of response, even if we decide not to investigate it.
Maybe in those counties, it's covered under their investigation procedure, the next section.
Maybe.
Could be.
We'd have to look at them. I think you just have them listed.
Yeah, we'd have to look at those. Does anyone like our procedure? It's pretty detailed.
Would you like a comment?
Yeah, I would.
One is, I don't hear anything about the ability to appeal decisions by the ethics board. Almost in all cases, people have that the door is not closed for them just because a decision is made or rendered to them. It's not necessarily a finite decision. That there's an opportunity for appeal. And another point that I would make, somewhat analogous to this process about, and that has to do with your reference to anonymity, that no one can make an anonymous complaint. We know that the statutes provide for the ability of anyone to sign a complaint regarding the open records law with the district attorney or whomever, and they can do it anonymously. So I think we would need legal counsel or advisement with regard to the whole question of anonymity and to the question of the ability of a complainant to appeal a decision. You know, I mean, you can always go to court, I suppose, if you're not satisfied with a decision. But I think I think what's going to happen here, and I think they have that in mind, is that when we're all done with this policy, we're going to ask the Corporation Council to review it and give us advisements on various elements of it. That would probably solve, any concerns that one may have. I'll leave it at that, sir.
Okay, yeah, I don't see anything on appeals in ours or any other ordinance, so I'm not sure how that would be addressed. As far as anonymous complaints, I'm not seeing in the Crawford, Sauk, or Iowa counties examples that they require that the complaints have the name of the person making the complaint. But we do currently require that in Richland County.
And
So-
whether or not we have, whether or not we can enforce that is another question. Whether we can accept a complaint anonymously, that's why I think we need a legal review of all of this.
Yeah, you might remember, Mr. Seep, we started with Mr. Wendell, and Mr. Wendell said, you basically have to tell me what you all want. So yes, of course, we'll have him look at this, but first we have to tell him what we think is best. And then, yeah, he may have some differing opinions, and then we can work through those once we get done.
I would like to hear his opinion regarding the question of anonymity and the question of the ability to appeal.
Okay, yeah, we'll get to that. Ms. Glassbrenner?
So both Crawford and Iowa do go into more detail in those, similar to what we have in our first section that you read, which is lengthy, in their investigation that you reference on that document, they go more into how they're going to do it, the hearings and et cetera.
Oh, okay.
One thing that I think is interesting, which I don't know if this would go under what we're talking now or into the investigation, but because it's included in our section currently, I'm noticing in Iowa County, it's saying that they shall conduct their hearings in closed session unless the person complained of requests open hearings, and they say that's pursuant to section 19.85, 1A and F. And in ours, I think it said only the first like when we basically when we decide whether it's going to be investigated or not, that one's enclosed. But then I believe ours made the point that it would be open after that. So I'm just wondering if we're in violation of something or if that's just different interpretations of it.
Oh, I'm sure. I'm sure different lawyers interpret all this stuff
Right.
differently.
I mean, I did think it's kind of odd that ours says that they're in open hearings. I mean, typically when we have anything related to an employee or to somebody that, you know, where we're discussing something like that, I feel like it's usually in closed session. So I think it's interesting that our ethics section for a complaint says that we're doing it in open session.
No, it just says the open meetings law. It doesn't say open
Does it?
session.
Okay, let me look at it again.
Yeah, I'm at the bottom of the investigation procedure under the Richland County column, and it just says that the hearing shall be in compliance with the requirements of the open meetings law, which does allow us to go into closed session for certain items. So it's maybe just a little confusing how that's stated.
Okay. Yeah, I think I was reading it wrong. That makes more sense.
So do you think, and I didn't do this before the meeting, so do you think the Crawford and Sauk County example investigation procedure, do you think when taken in consideration, you know, when thinking about that with the complaint procedure, do you think it
I
makes
think
sense?
their length is similar. I would say Iowa County's is less, but I don't think they're specific enough. But I would say Crawford County, when I'm looking through theirs, would be similarly in length to ours.
Okay. Okay, and I'm just wondering if maybe we should just go to the investigation section of, maybe we should just handle that in tandem here, see if we can get this off our plate today and then move on to another topic. So in Crawford County, this is, if you go to attachment 06B, other county ordinances, there is a section on preliminary investigations. And then time limitations, and then ethics inquiry board. This gets really long. There's a lot.
Which attachment are you on again?
06B, other
Right,
county
okay.
ordinances. And I'm at the top of page 5 of 20. Or if you're looking at the bottom of the pages, I'd be at page 5 of 6.
Preliminary investigations, right?
Yeah, preliminary investigations. Then they have a whole other section on the actual, I think if you skip down to 5C, about the hearing.
So can I make one comment?
Yep.
You guys were saying you weren't sure that Crawford in Iowa addressed the whole anonymous complaint. But they do say, if you scroll up to the bottom of page 4 there, it says the Corporation Council shall accept from any person a verified written complaint. I'm not sure what they mean by verified, but verified I would assume means you know somebody legitimate is putting forward the complaint. So I'm wondering if that's kind of, without saying it, they're not saying that it can't be anonymous, but what does verified mean in that sense?
To me, that means that it may be someone else filing the complaint for someone because they don't want to be immediately identified, but they can verify
That it is
that it is valid.
Right.
That other person wants to remain, whether it's a Jane Doe or John Doe situation.
I think that's right.
So they do allow anonymous, but they require that someone verifies that the person exists. Maybe they're not sharing that name with everyone on the ethics board, but they're verifying that the complaint's being made by that person. I'm glad you caught that. That's a good.
I
You may
actually
have-
almost like that better than ours with
Uh-huh.
just because I think that there are instances where someone might be afraid of retaliation. Yeah, which I know technically is not that's not
Right.
supposed to happen. We have that all written out, but
There may be cases where, I'm sorry, request to recognition.
Go ahead. Yep.
There may be cases, obviously, where a complainant may have his attorney, his or her attorney, submit a complaint to them. And of course, he or she would certainly deal with the question of protecting the person's anonymity in his communication to the county or the corporation council.
I'm almost thinking what it kind of sounds like we're liking the Iowa Sauk County example, but we can't just think about that complaints paragraph by itself. We have to look at it. We have to look at the next paragraphs 2, 3, 4, and 5,
Mhm.
or the sections, preliminary investigations, time limitations, and then they've got a little more detail on the actual hearing. If you skip 5A and B, you get to 5C. There's a hearing, and I'm kind of thinking that maybe what we should do is just. I wonder if we should just read out loud through those and see if those might make sense with the complaint procedure up in Iowa County and then, or Crawford and Sauk rather, and maybe then we'll like the Crawford example when we think about the whole thing. So section 3, preliminary investigations. Following the receipt of a verified complaint, the Ethics Inquiry Board may make preliminary investigations with respect to alleged violation of this code. A preliminary investigation shall not be initiated unless the accused officer or employee is notified in writing. The notice shall state the exact nature and purpose of the investigation, the individual's specific action or activities to be investigated, and a statement of such person's due process rights. If the Ethics Inquiry Board finds probable cause to believe the allegations contained in the complaint shall be referred to hearing pursuant to subsections 5A and 5C below, before the Ethics Inquiry Board. So then maybe there's a time limitation section. I guess I'll just read that. The board may investigate any complaint properly filed with it. However, no action may be taken on any complaint which is filed more than 1 year after a violation of the ethics code is alleged to have occurred. And then I'll skip to 5A and 5C like they suggested. So the Ethics Inquiry Board shall be responsible for investigating a complaint and conducting a fact-finding hearing pursuant to subparagraph 5C below in any case where the Ethics Inquiry Board has found that probable cause exists for believing the allegations of a complaint referred to the board after preliminary review pursuant to subparagraphs 2 and 4 above, which we've already read. And then under the hearing, it says the Ethics Inquiry Board may hold and an individual against whom a complaint has been made and where the complaint has been referred to the Ethics Inquiry Board may request a hearing before the board. The board shall keep a record of the hearing. The board shall have the power to compel the attendance of witnesses and to issue subpoenas as granted to other boards and commissions under 885.01 of Wisconsin statutes. And then there's 2 steps. 1, within 10 work days of the conclusion of the hearing, the board shall file its written findings and recommendations signed by all participating board members, together with findings of fact and conclusions of law concerning the propriety of the conduct of the public official. If the board determines that no violation of the code of ethics has occurred, it shall dismiss the complaint, and if requested to do so by the accused, issue a public statement. Number 2, no recommendation of the board becomes effective until 20 workdays after it is issued or while an application for rehearing, this is great, this is what Mr. Seep wanted to talk about, or rehearing before the board is pending, or the board has announced its final determination on rehearing.
What's the definition of board there?
It's the Ethics Inquiry Board.
Okay.
Yeah, Supervisor.
Frank, thank you. So I'm in reading the Richland County ones. It talks about the complaint shall be filed with or mailed to the county clerk. Where in this process are we having our county administrator? Should that be going to the county administrator? I'm not sure. I see some of them are going to the corporate counsel, some are going to the county clerk. I don't know how in the decision-making process that works best with the administrator's position. Thoughts, Clint?
Seems to me that the administrator would come into play when a final decision is made and a determination of what action should be taken, that the administrator would be the person who implements at the direction of the board the action recommended by the board.
Okay, Mr. Langreich, your thoughts?
I don't know how that all plays in together. From a personal perspective, it becomes a little dicey if I'm involved in actions against one of my 21 bosses.
Yeah, I know.
So I see why they would default to the county clerk as an elected official and then corporation counsel that's kind of insulated through an administrator position, if you will. But whether it's legally or illegally appropriate, I'd have to probably talk with Mike if that was something that you wanted to further tease out.
No, thank you. I didn't, thank you for that perspective of how that works. I think, yeah, leaving it with either the corp or the county clerk, then to me makes more sense. So thank you.
Yeah, because we're taking things that are employees, and on that, where our county administrator would be in charge of, the employees and the directors, that would go directly to him. But I'm not sure who this goes to. I mean, I guess through the county clerk. It's a little murky.
Well,
We do need to decide. So in the last action we took on advisory opinions, we said that any person can apply in writing to the ethics board for an advisory opinion. We didn't specify the person.
Mhm.
We didn't say the chairperson of the ethics board. We didn't
Mhm.
say the county clerk or the corp counsel. We kind of went off of what they did for corp counsel. So we just need to decide what person receives. We need to give direction to people. Who do you submit it to?
Mr. Chairman,
Yep,
when I can be recognized,
yep.
in the past, complaints have been routed to the county clerk, who would route them to the appropriate body or body chair. Um, the county clerk as well has traditionally been, and I think by statute, is the repository of record for personnel documents as well as all other records of the county. If I'm incorrect on that, or if there's been a change, then so be it.
Okay, so who do we want to have these go to? We just keep it with the clerk, or seeing head nodding from Supervisor Fleming?
Yeah, I agree. Obviously, Bob asked the question and it makes sense that it goes to the clerk, who is an elected official, versus the administrator. Makes sense.
I mean, I like consistency, so that would be my only caveat. I mean, we said in the advisory opinions part, submitting to the ethics board, but the concern with that is, what if there's a problem with one of the members of the ethics board? So in that sense, then I would agree that for this portion of it, it does make sense to have it be a somewhat neutral person, whether that be county clerk or the corporation counsel. But I would probably lean towards county clerk.
Okay. Yeah, I think someone having a complaint about a county board member is probably a little higher than the clerk. And we're all county board members if we keep the ethics board as part of the county board. So they might be the most neutral possible person.
Right.
And we could always go back and change our advisory opinion to say, send it to the county clerk, who will send it to the ethics board.
So how far do we get into the tangle of, if there's a question, if there's a complaint filed against an elected official, in this case, maybe the clerk, who would you send it to? Do you then send it to corporal counsel? You know, that whole question, that tier keeps moving depending upon where you want to place it. I like the county clerk position. I guess I would suggest that any letter of complaint, if it happens to go to corp counsel, the focus would be it goes to the county clerk. If the administrator were to get it, if someone were to mail it to the administrator, then it has to go through that chain. That would be my suggestion.
If you wanted to give yourselves an option of to the clerk or to corporation counsel, in case it's one of them, If it's both of them at the same time, then we probably have some bigger problems at hand. But, and then,
I kind of like that idea. What if we just say to the clerk or corporation counsel?
That's what I was thinking too.
Okay, okay. So, after listening to that whole Crawford County example, the complaint procedure, the investigation procedure, besides who people submit the complaint to, was there anything else in that example that anyone didn't like?
I don't love the whole not giving them a time frame and saying anything within a year,
That's
basically. I
right.
just think that seems excessively long. Because it didn't say like it had to be, at least unless I'm misreading it, it didn't say like it had to be within 30 days. I do like that on ours, just because I feel like for timeliness.
Now, but under time limitations, that was just, you can't make a complaint if the alleged violation happened more than a year ago.
Did I read that wrong as well?
It's at the top of page 5, second paragraph, time limitations.
No, it says any complaint, which is, oh, after, okay, yes, I did read it wrong.
Wait, where is that?
Top of page
Thank you for
5.
catching that. That makes more sense.
Yeah,
Still, they don't give a time frame though for responding to the complaint itself.
I thought they
Can
did.
I ask a question?
Yes, hold on just a second. So under the hearing section, it's
That's
on
at the conclusion of it. It doesn't say how much time they have to even have the hearing.
within 10 days of the conclusion of the hearing. It doesn't say how quickly you have to have the hearing.
Right.
What about, no, it's in the complaint section. It's back up there. The corporation counsel shall forward a copy of the complaint to the accused officer, employee, and
Oh,
ethics board within.
there it is.
Yep.
Gosh, I'm not good at reading today.
That's okay.
It's a lot to read.
Yes, Supervisor Gentis.
So I'm confused because a complaint is different than breaking the law. I mean, I'm just thinking of the Me Too movement or something where somebody a year, maybe 2 years later, and aren't there rules for statute of limitations? Are we supposed to be, is this following into that, or is this a different kind of level of complaint?
Well, if we go with what Crawford County, their language, they give a year. If the complaint happened more than a year
We
ago,
saw that, but that's why I wonder if that's legally right.
I think that's a different level. If you're talking about an actual crime, that's
Yeah, that's
something
what I'm
that
sort of
we're
wondering.
not going to be.
That's what I was thinking, right? It's a different level.
This is
Right?
an ethics violation.
Yeah.
now some of those might go into the realm of crime where something might get referred to the DA's office, but more typically, I think these are lower level things.
Yeah,
that we're
I
talking
just wanted to.
Yep.
The one thing I see on there, it says if no action on the verified complaint is taken by the Ethics Inquiry Board within 30 days, the complaint shall be dismissed. I mean, obviously, we just went through COVID and a lot of things got delayed and
Yes,
delayed and
that's true.
delayed. So I just wonder if the 30 days is too short of a time frame.
Would you maybe suggest like 45 or 60? Is that what
60
you're
days,
thinking?
maybe.
60 days? Okay.
Especially for dismiss.
Yeah, to completely dismiss because people couldn't meet because of an emergency situation, or there could be a flood in the county, and this is the last thing that we're thinking about is we're dealing with flood issues.
Yes.
I'm just saying if there's some sort of emergency or health emergency, I just feel 30 days is probably too short of a time frame to just completely dismiss a complaint.
Okay, I'm comfortable with 60 days. It gives us more flexibility. So, okay, so that's, I think, the only thing besides it going to the clerk or the corporation counsel, we wanted to change that also, give it the option of the clerk instead of the corporation counsel. And then the 60 days thing. So those are the two changes I'm hearing
It doesn't
so far.
specify, unless I'm again misreading, doesn't specify what the complaint should contain. Now, I know ours said we're going to take anything as long as it's in writing, but here's what we prefer. I don't know if we want to get that detailed, but I think it's good practice for a complaint to have the items contained that we did specify.
So Richland County does have a list.
It does.
Yes, it does. The name of the alleged offender, the approximate date.
That's what that's what I was saying. Crawford's does not.
Oh,
Can you
Crawford's
read-
does not, I see.
Yeah.
Can you read all those just to remind us?
Section 8A 1 through 6 Number 1, the name of the alleged offender. Number 2, the appropriate date, approximate date of the alleged offense, if applicable. Number 3, the nature of the alleged offense. Number 4, any supporting facts known to the complaining party. Number 5, the date on which the complaint is being submitted. And number 6, the name of the person filing the complaint.
Okay, so maybe, and I'm looking at Crawford County's, they just say they want the name of the person who's alleged to have violated this code and the material facts. So ours is just more expanded than theirs. They just want name, material facts. Ours is 6 things. So I'm comfortable with our 6 things just being inserted in here and replacing that sentence. Gives more guidance. Seeing head nodding, agreement. Okay, so let me keep track of these. We've got clerk or court counsel. We've got 60 days instead of 30 days. And then we've got our, what would these be called? The complaint components. We want Richland's list, not Crawford's list.
While we're on that though, I know we're really getting
That's
detailed
okay.
here,
That's
but
okay. We're getting there.
it does say later, we do make it clear that, how does it say? The counties, oh, this is the form. I don't know if this is different than what they were just listing. Because in E, in our section, it says the county's ethics complaint form is only suggested, and ethics complaints which comply with this ordinance but which are not on the form shall still be considered by the ethics board. Is that stating that you still have to have all of those components in order to be considered? It just doesn't have to be on the official form? Is that how I would read that?
That's what I took it as.
And I
Okay.
think I requested the form and never got one. So I don't know that the form exists today. And so I think if we
I
go,
feel like if we have those, that's enough.
this is
right?
enough, right? And I don't, if we mention that, oh, by the way, you don't have to do all those things that we just mentioned.
Right. It
I
just,
don't like that. We just need to be clear. This is the information we need. You got to give it to us or else we can't look into it. Okay. So I think what we're looking for, and if I'm not hearing any others, is we're looking for a motion to adopt the Crawford County complaints. See if I can get all this. Complaints, preliminary investigations, time limitations, ethics inquiry board, powers, duties, and hearing section. So all those sections I just read off with 3 exceptions. And the 3 exceptions are adding the clerk as a potential place to submit complaints, having 60 days instead of 30 days for the ethics board to complete its work, and to include Richland County's list of complaint components that are needed instead of Crawford County's.
One thing we didn't really talk about was the ethics inquiry board. Like this says there's 3 members, how it's done. I guess I don't even know who's on our ethics board or how
That
many.
comes later.
Okay.
And so if you go back to your cover sheet, 06 ethics review, scroll to the very top, we will handle that after we get all this sorted out.
Okay, I just thought you were including that in the stuff that you just listed.
Okay, just the ethics, just 5A,
Okay,
not, not 5 ethics inquiry board, not the section before 5A,
okay.
just 5A. Okay, any other discussion? Well, I'll make, how about I'll make that motion that I just read off if someone will second it? If you want to.
I'll second it with some discussion.
Okay, go ahead.
So once this is written, before it goes out, do we get to see it again? Okay, just good, thank you. I see that, oh yes, I'm just trying to make sure that gets expressed that, yeah, to put it down on paper and then physically see is gonna be better in the end to
Right.
finalize it.
Yeah, so kind of my vision for all of this whole process we're doing is we're taking all the language we adopted and then we're putting it together into one ordinance and then we're reviewing that entire ordinance.
Okay.
Then we'll forward that to Mr. Wendell and then the county board. for their consideration. So,
Perfect.
But at present, this is a draft.
yeah, oh yeah, very drafty, very drafty. It just takes a while to put together a draft with 9 people and, 20 topics. Okay, all those in favor of that motion, please say aye.
Aye.
Opposed, say no. Okay, that motion carries. So we did complaints and investigations. So next time we'll dig
Wow.
into, that was pretty big amount of stuff today. So next time we're going to dig into enforcement, and then we're going to go to the top of the chart on the page 2, and we'll talk about the governing body, the purpose of ethics, and the positions covered, which we've already kind of gotten into the positions covered a little bit, but we'll kind of we'll wrap things up hopefully in January so that we can draft an ethics ordinance for February. I think that's the goal here. Okay, unfortunately, I need to take just a 3 to 4 minute recess. I got to use the restroom if folks are okay with that, and then we'll handle our next 2 items. Thank you.
Thanks for the information.
So we'll continue on. Thanks for letting me take that little break there. So,
Oh, you're quite welcome.
so agenda item number 7, comprehensive plan.
Mhm.
So at last month's meeting, we reviewed a draft RFP and budgets for other comprehensive plans, and they range from 15 to 80 grand. The committee approves forwarding the comprehensive plan to the Finance and Personnel Committee for funding from the American Rescue Plan Act, and that was approved by that committee at their November 14th meeting without a dollar amount attached, and we explained the reasons for that. So what I did today is I drafted, I changed the RFP based on some feedback I got from Supervisor Glassbrunner, and Supervisor Caro weighed in on it as well. He took some time and went through it. And then I've drafted a resolution below. So maybe I'll just go through the RFP changes first, and then we can get to the resolution and see if folks are comfortable forwarding this to the county board for December. So if you go to attachment 07A RFP, it's a 9-page document, and starting on page 3, that's probably where the significant changes start. So Supervisor Glassbrunner had mentioned maybe go look at the tourism website, see if we can sell ourselves a little bit more. So I spent a little time yesterday selling ourselves a little bit more. So there's some new language in there. Anyone wants anything read off, just let me know. Otherwise, I'll just hit a high level of what's changed. These next changes came from Supervisor Caro. So he wanted to make sure we were clear on page 4 that this body would be the body reviewing the work of the comprehensive plan vendor. So not just managing them, but also reviewing them. So that word is added at the bottom of page 4. He knew about a couple other studies that I hadn't thought about. And one is the 80 German warehouse visioning reports. Another at the top of page 5 is the housing and workforce study that the Southwest Regional Planning Commission completed. And then that made me think of the UW Richland campus plan. There's a plan out there. Then on page 5 in the middle, updating data, Supervisor Caro also had some thoughts on updating data. He wanted a sentence added in there. Or I don't know if he said a sentence. He had a lot of thoughts. I think maybe I boiled them down to a sentence, which now says the updated plan should review or analyze data in the past plan to be used to inform the accuracy of the new plan. New data sets to evaluate may also be proposed. So he had some good thoughts about that. So those are included there. On page 6, let's see, Supervisor Glassburner had some, let's see, you looked at the De Pere, Wisconsin RFP, I believe. Yeah, I think it was De Pere. I think that's what I had written down in my notes. And you liked the words that they were wanting their comprehensive plan to be public friendly, modern, brief, graphically rich. So I just included those words in here. Steve wanted to make sure we were talking about measurable goals, not just goals. And then Supervisor Caro had the idea of, not only just listening to what the community says and that should guide the goals and strategies of the plan, but also let us know what your own expertise is as a vendor and tell us about any topics that weren't talked about in the community engagement process. And then in one of our last county association magazines, they had a whole issue on developing a capital improvement program or plan. And they said in there, the way you develop a capital plan is by using your strategic plan and your comprehensive plan. I thought, oh, we could use the comprehensive plan to help with the capital plan too. So that's why that sentence is added there. Under proposal requirements, I just added two words with deliverables after scope of work, just to be clear about identify what you think you're giving to us at each part of the scope. I think that was Steve had something there that made me think of that. And then under the selection criteria at the bottom of page 6 and top of page 7, he thought we should put a little more emphasis on other relevant projects, the work they've actually done. So he suggested upping that from 10 points to 20 and then lowering the resumes and the 40-page limit from 10 points to 5 points. And then under budget, we talked about this last time, and I can just hear it. I know that they're going to have questions. If we have vendors who are interested, they'll say, what about the budget? So I thought we could just head it off and say, while the county has not set a budget for this project, vendors should be prepared to propose a competitive budget compared with recently completed comprehensive plans in communities similar to Richland County. And then Supervisor Caro caught on the very last page, item 6, that the first sentence didn't make sense. The whole number 6 didn't make sense. And I realized that the first sentence was probably not saying anything clear, so I just got rid of it. I must have pulled that from another RFP. So any questions or thoughts to share on those changes? Okay, so then going back to the cover sheet, a resolution authorizing the issuance of a request for proposals to update the county's comprehensive plan. So there's a bunch of whereas language about why we're doing this. And that the purpose of the plan is to inform decision-making and guide the county's development over the next 10 to 20 years. And we've got in here that the finance committee has approved funding. So we're asking the county board to give us authorization to issue the RFP for a comprehensive plan. And we're telling them that we are going to return to the county board to request approval for vendor selection. And if you go back to the RFP, the schedule for that would be at the county board meeting in March. So we would issue the RFP at our next meeting, January 5th. We would finalize it then, and then we would go back to the county board in March to approve a vendor, and then there's a bunch of steps in between.
Mr. Chairman.
Yeah.
I'm having a little difficulty reading here, so perhaps you can shortcut this. It was reference to the whereas and whereas and whereas. This whole project is premised upon a state requirement or a mandate, right?
Yeah, that's the whereas. The county's comprehensive plan was last updated in 2006, and whereas state statute 66.1001 requires. Yep.
Yeah, I see it now. Thank you.
Of course.
Yeah. Forgive my reading problem.
No problem at all. Okay, so if that sounds good, just looking for a motion to forward a resolution to the county board to move forward with issuing an RFP.
This is Bob, so moved.
Okay, motion by Frank, second by Glassbrenner. Any further discussion? All those in favor say aye.
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 Opposed say no. Okay, that motion carries. So thanks for that, and we'll have that the December 13th county board meeting. And then agenda item number 8, housing authority responsibilities. Mr. Langreich.
Mr. Chair, looking today for a motion to dissolve the existing CDBG committee with reductions of paragraph C of the housing authority function. So perhaps better stated of dissolving the existing CDBG committee functions from housing authority. Background on this item is requesting this task to the housing authority be removed from the CDBG committee responsibilities of the housing authority committee. If future CDBG programs are implemented, the county may stand up a committee as needed. Your committee structure document, of which you're in charge of, has housing authority on there with paragraph C stricken out, is what the intent is today. A further background on this item is that the Richland County Housing Authority has acted as the curator for funds of a legacy CDBG program that is concluded and has acted as secretary for the CDBG committee. Both the county and the housing authority have sought guidance from the state and federal agencies as to our understanding these funds' purpose and disposition have outlasted the intended program. At this point, these funds are considered defederalized and available for the county to use at its discretion. I'm requesting these funds be returned to Richland County with intentions of using these funds in continuing county support of Richland economic development. I'll be requesting Richland County Economic Development prioritize community and workforce housing in Richland County. The recall amounts you'll see there in the existing account is about $87,000, requesting $13,000. They'll be left with housing authority to supplement for their acts of acting as curator and of secretary. They've been kind of paying the bills for handling this committee through Section 8, which could be called a question on audit. So this is kind of payments for those services, thereby recalling then a total amount of $74,553.63. With this request, the county would ask that the housing authority to please include any interested properties that these grants were given out to that may be still existing as liens on them if they are depending on their disposition. And then you'll see that there was action on this by finance and personnel to do the recall. Your function here today in supporting that resolution then to the county board is to then remove the CDBG functions from housing authority. And then a resolution is also attached for your review, Mr. Chair.
Okay, so we're looking for a motion to dissolve paragraph C under housing authority in the committee structure document.
Also move.
Okay, motion by Frank,
Second.
second by Seep. Any discussion on this?
Yeah, so Administrator Langreich, is there the CBD money, is that program over and done? Is the state going to be reinstating anything that we know on that?
No, to the best of our understanding, that program is expired out and they are defederalized funds, which do not come in with any types of restrictions. The idea of bringing them back from housing authority and then pushing it into economic development again is the idea that those monies were taken by federal income tax for the purposes of housing. So trying to put that in the initiative through economic development to encourage local area housing feels like the right thing to do to honor why folks were taxed for those purposes.
Very good, thank you.
Mr. Chair, may I speak?
Yeah.
So Daniel McGuire and I were on that board. We're no longer officially on that board now. I think I'm still on some other part of it, but, and I had talked just briefly with Administrator Langreich. I'm not really opposed to the economic development working on housing. I felt that the spirit of that money originally was to help people who were economically challenged or had problems, and that the money should go toward, in my mind, either be identified for that and not where I haven't really been to a registered economic development board recently, but it seems to me that their purpose was development for upper end housing. And I feel that there's a lot of housing in town that needs to have funds, and the neighborhood housing I know is going under some sort of reconstruction in their administration, but I felt that it was more the spirit of the money to work toward neighborhood housing, or if it goes to Richland economic development, that the spirit of this money should be toward in town housing or housing in the whole county that is with
Lower income?
Lower income.
Yeah.
So I just am uncomfortable with some of it just being automatically moved.
Is that an amendment?
No, it's discussion.
Yeah, and our role today is just, are we comfortable removing that function from the housing authority? The implications of it are detailed below, and we're not being asked to take any action on those things. Finance and personnel took action, and they have the role of that, correct? And
There-
and what goes to county board? Just the money part? I'm sorry, just the committee structure part, or does the money part go to county board too?
The resolution then will capture both pieces of it of requesting those funds back, and then also amending the structured document to take those duties from housing authority.
It says that in the resolution, where did the funds go?
I see.
So that's what I'm commenting on. I know we're talking about 3 different areas here today. I mean,
We're not being asked to forward this resolution to the county board. All we're being asked to do is remove that paragraph from the committee structured document. But you're kind of saying, I'm not comfortable with the resolution, right?
it says on here that we have a resolution that we're supposed to be doing, right?
Yep, let me pull it up here.
Isn't that number 8B? Am I not reading this correctly?
So this is the resolution that you'll see up there. It has the where they have acted as the curator, where we understand that the funds, to the best of our knowledge, are defederalized and available for county's discretion. The purpose of the CDBG committee will have been exhausted because of the program having kind of outlived its purpose at this time, and then asking then the strategic planning committee has taken action to recommend dissolving that function of the housing authority. So it's kind of the 2 different parts there. So then we get to the now therefore be it resolved that the money is recalled, and that the funds are going to be used by economic development. So it's kind of all tied into one resolution of dissolving the committee function of housing authority and recalling those funds back for purposes to put through Richland economic development.
But you're thinking of offering this resolution from the finance and personnel committee, because that's what it says below, correct?
It does, yep.
So why is it on our, I'm confused then.
There's 2
No,
different,
you
there's,
just-
in order to do this action, it requires several different functions, one of which you have the authority underneath being in charge of the structured document
Yes,
and what folks kind of do.
in the
And the
letter.
other part is the financial thing of recalling the funds.
Mhm.
So the county board would be asking then for finance, did you take a look at this for purposes of recalling the funds? And they'd be asking rules and strategic planning, did you take a look at this of dissolving those functions from housing authority was why it's being brought to both bodies, if that makes sense.
So the resolution is just an FYI. This is how it would look coming from the finance committee if we approve this action today. It'd be tough to get this resolution out if we didn't approve this action. You'd have to change the resolution, so. We're not being asked to forward a resolution to county board. We're
I
just.
understand now.
Okay, got it.
Because it was on here, I thought we were going to be both doing it.
I don't know if we've done this before, but if you would want resolutions that are co-signed by 2 committees, we could.
No, I'm not asking all that. I just, I still think the spirit of the money needs to be identified. That's why I'm,
Okay, so the motion before us is to dissolve the existing CDGB committee with the reduction of paragraph C of the housing authority function. So any more discussion on that? Okay, all those
Mr.
in-
Chair. Mr.
Yeah,
Chair.
Chair Brewer, yes.
Yes, I'm listening to the discussion, and I think that, Linda, you could bring this up as an amendment then, when the board takes action to further tighten up the definition.
okay. I will, at the county board meeting, you mean, Marty?
Yes, yes.
Okay, I'll work on that.
Okay. Hearing no more discussion, all those in favor, please say aye.
Aye.
I,
Opposed, say no. Okay, that motion carries. So we're done with that item. Agenda item number 9, future agenda items. Mr. Frank, do you have any?
I do not, thank you.
Mr. Seat?
Not at this time.
Chair Brewer?
none?
Supervisor Gentis?
No?
Supervisor Fleming?
None.
Supervisor Glassbrenner? All right, then we're looking for a motion to adjourn to the year 2023.
Yeah, we're in the new 2023.
Okay, so the date, the first Thursday in January is the 5th. So we're looking for a motion to adjourn to Thursday, January 5th at 10 a.m.
I'll make a motion to adjourn the meeting to Thursday, January 5th at 10 a.m.
Okay, motion by Fleming,
And I have my
second by
pen
Glassspinner.
here.
All those in favor of adjourning, please say aye.
Aye, and I'd like to announce, after adjournment that I have happily entered into the